What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we are finally breaking down and reacting to Alan Jackson's interview on Turtleboy's show. It's a couple weeks old. Yes, I know that. Yes, I realize this has not happened yesterday, but so many people continued to ask about it yesterday during the video and all over all social media. This was by far the most requested thing that people wanted to hear my breakdown of. And frankly, I know the Brian Koberger press conferences may still be going on after the sentencing where we heard all the victim impact statements. And I don't know about you, but I needed a break from that. So this couldn't have come at a better time. Let's listen to this explanation and this back and forth. He really gives a very different interview than any other lawyer that has gone out and give interviews on the Karen Read case and trial. He talks so much strategy, so much about what they did and didn't do and why they did it, why they didn't do it. He does not shy away at all from the strategy change from trial 1 to trial 2. He really gives us a look behind the curtain into how this all evolved into what we watched together, which was Karen Read getting acquitted in trial number 2. So everybody hit that like button. Let's get to it. So it's a long interview as well. And we are going to go a little over an hour today. So everybody be ready for that. Be ready for some overtime. But I did cut out, a couple minutes here, a couple minutes there, like I always do. But the vast majority of us here, if you guys want to watch the whole thing, it's on Turtleboy's channel. And you can watch the entire unedited, unclipped interview of everything Alan Jackson had to say. But I got the vast majority of it and a lot of what I wanted to react to, talk about so many things we discussed here together on this channel throughout the trial about why did they do this? Why did they do that? What were they thinking? Do they regret it? Do they have any regrets? Is it now that we won, we have no regrets, right? Now that we've won, we don't second guess anything. We did everything right. Is that going to be the vibe? Let's take a listen together.
Pull back the curtain to a larger problem. And my hope is by the time that this thing is said and done, and we ain't done yet, by the way.
Really? What do you mean by that?
Well, some folks have said we ain't got to quit. There's a lot yet to be done to fix the problems that sort of germinated this issue. So stand.
Is that something you're sticking around for? Are you still you're still technically, you haven't I don't know what the word is. You're still Karen's attorney.
I'll always be Karen's attorney from this day until the next. I'm always going to be Karen's attorney. I'm not going anywhere. So if there is when there is a next chapter to this, you can bet I'll be involved. Is that something you?
So he said a couple interesting things right off the bat at the very beginning of the interview. They ain't got no quit. They are not done yet. He is not done working on this case. Now, what capacity does that mean? Are they going to file any civil actions against anybody specifically, individually? Any governmental entities, maybe? Will he be involved in that? The civil case, it seems like they're not going to be involved. I wouldn't think they would be involved, but potentially, could he be involved in that? Sure. Is he just talking about movie deals, book deals in her life? He's going to be involved. Who the heck knows? We don't know. But one thing we do know from the horse's mouth is he is not done representing Karen Read, number one, and they as a group are not done fighting for Karen Read.
You can detail more. I know we talked about this before, and there's some stuff you're obviously not going to be able to touch.
Yeah.
And that's one of those things.
That's one of those things that I'd rather allow the system to, look, I was very circumspect about the times that I spoke publicly. It was very, very, very curated in terms of the statements that I made on the courthouse steps. It was very curated in terms of the statements that I made or Karen made in any interviews. Those were nothing was by chance and nothing was happenstance. Nothing was sort of impulsive.
So when Karen Read.
Did you hear that? Everything was curated. Everything was planned. Everything was done just the way they wanted to. And that's a little shout out to the interviews, which I personally thought were not good for Karen Read. And a lot of people watching the trial were like, man, if they didn't have those interviews, they wouldn't have anything. We're not going to dive too much into his thoughts on that because he dives into that in much more depth later, specifically the purpose of those interviews, whether he thinks they were a good idea or bad idea, if he would change anything about those interviews, so much more on that later. But he said it right there. Everything they said was planned and curated. From the courthouse steps to the interview she gave on TV, every word was planned and they did it the way they wanted to. Nothing was by surprise. Nothing was just blurted out. Nothing was, oops, we wish we wouldn't have said that. So he's sticking to, that's going to be the theme of this interview. is they did it right. Every decision they made worked. They won, and that's how you look at it. No regrets. You've got to have a sack on you to say, we're going to do it this way and we're going to live with the consequences because we know we're doing it the right way.
On May 3rd, the first time I ever attended a hearing, blurted, no, it was May 24th, I apologize, blurted out suddenly that we know who did it, Steve. You know, that came out of nowhere. She just started talking. Was that planned? Or did she do that? Did she go rogue?
So Karen has never gone rogue in her life. So I'll revert back to the statement that I just made. Everything that Karen has done, everything we've done as a defense team has been highly curated for a reason. There's a reason why we've made every single move we've made. Our position was at the very beginning when Karen and I first started talking was we're going to allow the government to play checkers and we're going to play chess. So stand by. Nothing.
This is masterful. But by the way, his view on this trial and this case is just masterful lawyering once again. And the way that you package something, like we talked about how lawyers can package things, right? They can package a loss and make it look like a win. They can package a win and make it look like a home run, or a single and make it look like a home run, whatever it is. And that's going to be the way he looked at this case. And guess what? He won. And to the victors go the spoils, right? And history is written by the victors. All of the phrases and quotes and slogans and everything, when you win, everything just looks different. And throughout this interview, everything went right. Everything went according to plan because that's how we do it, right? That's how we plan it. That's how we package it. And if you're a client that's looking for a lawyer and you want everything to be curated perfectly and go according to plan and really do X, Y, and Z, hey, look no further than Alan Jackson. And guess what? He does an absolutely great job of weaving this together and explaining a very difficult and hard-fought case that was an uphill battle that they absolutely smashed. But it is very interesting to listen to this.
Nothing that Karen has ever said, or use the word blurted out. It sounded like she blurted it out, but the reality is nothing she's ever said has been a blurt or a mistake or impulsive. We've known what our theme and our theory and our methodology of getting the truth out was going to be from the jump, from the moment Karen and I started communicating.
So let's talk about the evolution of that. So David Yannetti is her attorney from February of 2022 alone until late September of 2022.
Till August.
Okay. And
y'all were introduced to me in September 25th, but Karen and I had begun our discussions in August.
Okay. And like me, the hook that got you was the arm picture. That was the one that stood out like, whoa,
100%.
whoa. 100%. That's not a car didn't do that.
Yeah,
okay?
It's been widely reported, and that's absolutely 100% true. As soon as I got the email and she said, let me attach a photograph. This is what the Commonwealth is saying. I did with a taillight. I immediately said, I'm in.
So she sends you that, and you must get pitched with potential clients all the time. And I'm sure everybody who contacts you is being framed. Everybody is the victim of corruption. Everybody's innocent, or like not everybody, but a good amount. How do you weed out the yahoos and decide that Karen Reed's legitimate and you're going to take this? And am I right that you obviously don't take every case that comes in your inbox?
I don't. I'm lucky. I'm fortunate. Our firm is fortunate. We do get a lot of calls, and there's a lot of calls that we want to take, but we can't. There's reasons why we can't. There may be financial reasons. There may be geographical reasons. I can't take a case in Alaska at this time because I'm trying another case at this time. Whatever. We do get a lot of calls. The thing that changed everything for me, and Liza, by the way, Liza has an office literally physically right next door to mine. Like we share a common wall. And I called her in with our very, very elegant intercom system, and it sounded a little bit like this: "Liza, get your ass in here!" Oh my God! I just screamed across through the wall, and she walked in, and I told her about this email and this conversation that we were about to have, and it was probably about. I may be wrong on the time. Karen would probably be able to fix it. She has a better memory than I do, but it was about a 15-minute conversation, and I said, every hair that I have on the back of my neck stood straight up, and I was like, "This is not right. This is not. Everything that I'm seeing suggests." Something is desperately wrong with this prosecution. Mm-hmm. And look, I was only brought on as a very humbly, behind David as a consultant. I was
just a humble servant. He was brought in as a consultant. Yannetti was her lawyer. They called him because of some of the specialties he has. I think he says with some of the data in the case. And then obviously it spins into a lot more where he ends up becoming the lead attorney on the case. But this was all cool. I didn't know any of this. You guys know I wasn't following this from the jump. I basically followed it from the beginning of trial one until still today. Somehow we're still talking about this case. And it was really cool to kind of hear the genesis of how all of them got together. What they looked at doesn't surprise me one bit that it was the picture of the injuries to John O'Keefe's arm and Karen Reed saying, they said I did this with my car. And he says, no way. You don't need an expert to tell you that, right? I mean, we heard it from a lot of experts, dog bite, not a car, not a tail light, whatever. Talk about mechanics and math and all this stuff. Talk about all that, all you want. From the untrained eye, from just a normal person looking at that, it was so obviously not from a car. That is why he got into it. That was cool to hear.
Brought on as lead counsel, and that's my normal role when I take a case. I usually walk in with that imprimatur as lead counsel, and I control the entire case. And that's just how I'm built, and I've earned that over decades of trying cases. But in this case, I was like, okay, I'll take a backroom role and see what happens. As we began talking and we began discussing the case of geofence data and really technical cell phone data, which I was very good at the time. I started realizing there's a broader issue here. This isn't going to be a technical defense. This is going to be a full-throated, full-blown defense of an innocent woman. She did not do this. And if you want to call it, she was framed versus, which is what we really postulated in the first trial, versus the data shows that there was no collision, which is what we postulated in the second trial. And
that was interesting, right? Whether you want to say she was framed or there was no collision, we talked about she was framed in the first trial and no collision in the second trial. He believes both are true, but I thought that was very interesting that he's leaving that open to the general public, which is what kind of we said from day one. Like, the framed part might be hard to prove. You're taking on a burden to prove that. He'll talk about that later in the interview, versus what they did in trial 2, which I thought was the A+ defense all along, and they hit it out of the park.
Saw that. I mean, the beauty of sort of young law students watching this is they saw the transition between defenses. Both defenses were valid. By the way, I mean, I'm very proud of the fact that we acquitted her twice.
You did.
I
24-0.
Oh, sorry. Before they get into another topic, Peter, I'm curious as to why Yannetti was okay with Alan Jackson taking lead. Is that normal? So obviously I don't know the answer to this as to why Yannetti was okay with that, but I'll just tell you from my experience how this happens in some other cases. Number one, sometimes it's pretty clear who should be lead counsel. I'm not saying that's what happened here, but sometimes there are situations like that. Number two, sometimes lawyers don't agree to come on the case and actually try it unless they are lead counsel. Number three, the client can make that decision. I want this person to be lead counsel. That's the most common, is the client chooses who they really feel more comfortable with being lead counsel. Sometimes that happens with conversations between lawyers and clients individually or as a group. Or sometimes the lawyer just says, hey, I think you'd be better as lead counsel. I want you to be lead counsel. So there's a number of different ways it can happen. But yes, a decision actually had to be made for that switch to occur. It doesn't just happen organically.
Yeah, exactly.
Actually, by the way, we've heard from 6 of the, I've told by sources, all 6 alternates also said not guilty.
Correct.
So no matter who you picked,
we've heard from them too. Yeah, exactly. No matter who you picked, it didn't matter. There was no fix. There was no in. Whatever. Everybody that would have been on the jury would have acquitted her 100%.
Now let me ask you something. Was your change in strategy this time around affected at all by my interview with Ronnie? Because it seemed, not to toot my own horn here, but it seems like a lot of the things, like Ronnie it was painful listening to some of the things he said, right? But I had to ask him, and I had to maintain my composure asking, even if he was driving me nuts. But I thought it was really important that the defense heard this. Did you watch that interview, and did it shape how you changed your strategy in the second trial?
I did watch the interview. We all watched it. I that was sort of a must read, as you will, as you think about it. There wasn't one specific thing that Ronnie said that changed our mind. It was a sort of a panoply of, or a myriad information that was coming to us. Your interview was among the chief among them.
The car insurance question, you asked that one.
Absolutely. 100%. That came directly from your interview with Ronnie. Ronnie said, as you remember, obviously you asked the question, well, we thought that maybe her insurance company had some interest in hiring experts and doing such and such and so and so. And
that kind of makes sense. That kind of makes sense that a juror might reach that conclusion.
And that's why we talk about it as trial lawyers. Nobody can teach you more than a jury. It doesn't matter if they're wrong. It doesn't matter if they looked at something completely differently than the way you looked at it. You always can learn from them. What did they take? What did they pick up? How can you do better at explaining it? And whether anybody says it was a mistake or not, it was a significant change they made to make sure to tease out those details in an appropriate manner and to make sure they did cross off the very legitimate concerns the first jury had, that you're like, oh, duh, of course that makes sense. They could have thought it was car insurance. It obviously wasn't, but very important to learn and adapt, even when you think you are the greatest lawyer in the world and you can beat any prosecutor with your hands tied behind your back and you're lead counsel, and over your 30 years, you've earned the right to be lead counsel, and everybody will say you're a great lawyer. What makes you a great lawyer and keeps you a great lawyer is you understanding still you need to learn and adapt and progress and continue to grow.
They're not stupid. I mean, these are intelligent folks. And part of the issue that we had was perpetrating what we always considered and what I always said from the beginning is perpetrating a fraud on the jury. We are perpetrating a fraud on the jury. We are supposed to be in a system of truth. That's it. Full stop. That's the alpha and omega of a trial. Give me the truth. That's all I care about. Give me the truth, and I'll take my lumps, whatever that may be. But the Commonwealth has to take their lumps too. And Judge Cannoni, very specifically, was not going to allow us to tell the truth to the jury. The fact that she hid the feds from the jury, not once, 2 times, even after being slapped down by jurors, not slapped down by us. I mean, we were always respectful to her. The jurors said, once we found out that these were feds, why didn't you tell us that? That makes all the world a difference.
Yeah, it did.
We thought they might be insurance folks.
And what was her argument? Because it would bias the jury, but doesn't all evidence bias a jury? Isn't it the point of evidence?
No, her argument was more along the lines of, you have my ruling.
Okay, because I said
he's being a little hyperbolic. The reason for the ruling is the relevance is not outweighed by the prejudice. That's the point, is that if you hear the FBI hired these experts, that the jury would think, oh, wow, that means they must be right. And that means that the investigation was all done wrong. And we don't want to let them go that far down the road. Now, he brings up a really great point here. So he's about to say something like, no judge I've ever practiced in front of would ever have kept out the feds. He's got more experience than I do. And, he's the best lawyer in the world. Everybody is, Alan Jackson, the greatest lawyer in the world. I agree. Absolutely amazing lawyer. So to disagree is totally fine. It doesn't bother me to disagree. And I'm not saying I know more than him. Okay. Just different experience. Every judge I've practiced in front of would never have allowed it to go the way that most people wanted to, that the FBI hired these experts and these experts said that investigation is wrong and the people that looked at the taillight were wrong and this did not hit a car and they should have dropped the case. No judge would have allowed that. And so I was going to disagree with him. But then he put the caveat on exactly how he would have wanted the jury to hear it. And I thought it was a great explanation. And I do think that most judges would have allowed that explanation because it's not prejudicial. It's true. Like he's saying, and that's what good lawyers can do. He takes what everybody, in the media and in the world wants to take and smash down your throat, like, show the jury how corrupt this DA's office is. And he doesn't use that. What he says is, this is a very innocuous way you can tell the jury the truth without putting the sting and the prejudice on it that we're worried about, but still not lying to them. And that's the big problem. We don't want to lie to the jury, or as he says, perpetrate a fraud on the jury when we can just tell them the truth and trust them with the truth, right? And he does a really good job of explaining exactly how this should have been said to the jury.
So
because I said so.
Yeah. Now, do you think, you've been doing this a long time, do you think she's one of the small percentage of judges who would not allow that to be mentioned? Or do you think if you had any other judge, do you think that judge would have done the same thing she did? Or do you think they would have allowed FBI to be mentioned?
My experience is that I think every other judge I've ever been in front of in my life, every other judge, and there are those probably number not in the hundreds, but in the thousands. Every other judge would allow that in.
Really? Every other judge? Wow.
Every other judge would allow that in. Every one of us on the defense team in the first trial and the second were gobsmacked that she would not allow in even a modicum of information. We can't go into what the investigation consists of. We didn't want to know who the investigators were. We didn't care if it was the DOJ or the FBI, whatever.
And you notice how he said, so here's some other people saying this, but the hiring by the FBI to go over the evidence is the truth. I agree. But you'll hear him even say, there were certain things we didn't need to go down that rabbit hole. We didn't need to dig into. We didn't need to say, because lawyers know certain things are just never going to be admissible, even if they are true. So I get it, but there's always going to be things that are true that are still not admissible for different reasons in court. So it's not like every single thing that's true comes into a trial. It has to be relevant, has to be reliable, all those things too. But he's about to explain the way that I think would have been great to tell the jury exactly how the feds were involved.
To be able to say the federal government opened an investigation and this is what they hired ARCA, and ARCA worked for and was commissioned by the federal government. And this is what they found, period. That does not in any way, shape, form, or fashion prejudice the Commonwealth. It never would have,
and if she would have allowed it in, if I could speak for Karen Reed's defense team, they would not have abused that. They would not have then tried to make the argument that because the feds are involved, that means the Commonwealth is wrong. My opinion. I don't think they would have done that. If they would have, that would have been problematic for them, and it should have been problematic for them if they would have really taken it a step too far. But if he would have gone with that, if he would have just gone with that explanation, I think that would have been fair, and I think that would have been appropriate to tell the jury. I do agree with him there.
The Commonwealth was so adamant that if that was known, it would allow such inherent credibility to be gleaned about ARCA. She wouldn't allow it to happen. She was.
All right, I'm going to skip ahead a little bit here. They do talk about how they think the judge hated Jackson and everybody on their side, and how she kept saying things like, that's not how we do it in Massachusetts. Even I think he called her angelic, Ms. Little. And then they talked about how, just it was very clear that there was a vibe in the courtroom, and he doesn't know why, because he treated her with respect. He respects all judges. He respects the position, the chair, the robe, etc. It was a little bit of an interesting clip, but again, to make sure we get as much of this interview in as possible, I've got to jump ahead here and there.
That must have been hard. So let me ask you. So first question, we talked about addressing this earlier on. There's a lot of talk on the internet right now.
Oh, and one other thing I didn't mention, and this was also kind of cool when listening to this interview. I think everybody has like their opinion of Turtleboy's on the defense side, whatever. Obviously, he's on the Free Karen Reed side. I don't know if he started the movement, because again, I wasn't there in the beginning, but it feels like it. It was cool to see him disagree with Jackson on a couple things, and to say, I disagreed with this, I disagreed with that, because to me, that shows a mutual respect, the ability to discuss things, the ability to have your own thought, but even more importantly, that Jackson was cool with it. Jackson's like, let's talk about it. Let's talk about what we agree with, what we disagree with, trial strategy. Jackson couldn't be more confident. In a lot of the interviews that have happened around everybody connected to this Karen Reed case, there have been things that have been, we can't talk about this, we can't talk about that, we can't push this or really dig into that. Seemed like Turtleboy mentioned that there were some things that were off limits, but didn't feel like there was a lot off limits besides like maybe what's in the movie and what's in a future lawsuit or something they may be filing. But from my perspective, one of the things that was in the part that I skipped that he talked about was like, I disagreed with your objecting to the courtroom setup or which courtroom you're in, because then it ended up hurting you. And Jackson was like, I still think it was worth it. We had to make that decision. I do think she tried to make us eat it with this smaller courtroom, but that's not the only thing they disagreed about. There's going to be some other kind of trial strategy things that Turtleboy disagrees with, and Jackson's going to defend in this interview, which I thought was really cool and doesn't surprise me one bit about Alan Jackson's personality. That's exactly how I would expect him to respond to somebody with legitimate questions. And again, at some point, Turtleboy said something like, I'm a big fan, or, I'm on your side or whatever, but I do want to, talk through some of these things we may disagree with. And I thought that was good.
Spoke about this of like the defense team should distance themselves from Turtleboy, right? That like, they're playing it smart by not coming on his show. And then you called me and you were like, I want to come on. And why is that?
Because I didn't believe that bullshit. That we were, I know it's not true, that we were trying to distance ourselves from Turtleboy, from Aiden Kearney, from the magnificence of what you did, the crowd daddy, right? You created a lot of this, you generated a lot of this verve, and we appreciated it. We're deeply, deeply, deeply grateful. I talk to Karen every day. Every day I talk to her. I don't think that there's been a day since the verdict that I haven't spoken to her and or her family. And every single day, she tells me how grateful she is to your viewers, to the folks that populated the streets and the sidewalks and wore pink and gave this beautiful "I love you" sign that has resonated through not just the Commonwealth's community, but through the nation and through around the globe. I mean, we've gotten, I'm sure you have too, we've gotten accolades and love and support from Australia and Ireland and China, all across the globe. That's in no small part because of folks like you. There's a element of a come down. She has to have that, right? She has to, there was no distancing of ourselves from you specifically, but she needed to come down, and she almost crashed a little bit. Have you ever had a situation where you've had an adrenaline?
He's about to explain what I say basically every time we talk about a trial, and I talk about lawyers coming down from the adrenaline rush and what it's like and how your brain is so on and you feel so tired and it's literally a crash. And I always talk about it from a lawyer's perspective, obviously, because that's my experience. But he explains it from the client's perspective because he's been getting it from Karen Reed on just how big of a crash is. And the way that he explains this was so eye-opening for me to think about it from that perspective, because I've talked to my clients about it. But again, I always think about it when I'm the one trying the case, about my crash, my adrenaline crash, which is not that long. It feels like a crash, but it's not that long. You can understand why Karen Reed's is a little longer.
Adrenaline, you're just pumped with adrenaline, and the after effect of the adrenaline is I just gotta come down. Now think about that. Normally the adrenaline is, you're about to have an argument with someone that you love or care about. You're in a bar and someone looks at you funny or what, and the adrenaline goes through the roof, and then you've got this come down, or it's an incredibly exciting event and you have this come down. Now multiply every single day of your life, every day, relentlessly, every day, with Tully and Buchanan and Proctor and Michael Morrissey and Lally and Brent. Every single day, you're dealing with people who believe they're being paid to destroy you. Now, expand that to 3.5 years. 3.5 years, every day, 365 days a year for 3.5 years, over 1,000 days of that. And then it's like, bam, it's just done. She won. It's over. It's over, Aiden. So the idea of Karen running around and doing every podcast or every interview, we were asked by everyone. I mean, everyone, you name it, we were asked, CNN and Fox News and Good Morning America and the Today Show, everybody asked. She just needed a minute. And I get it. I get it from her. I get it. My heart goes out to her. I don't know. I mean, I was in sort of the fire with her, but not really, because nobody can really understand what it's like. You know what it's like
Yes.
to be accused. You know what it's like to be falsely accused, Aiden. Very few people do.
Yeah. And again, you can't blame them, right? It's their prerogative. They can do the interviews they want to do. He obviously chose to do it this way. I think that's spot on. And I don't think anybody really blames anybody for doing interviews or not doing interviews. He does talk a little bit more about it later that made me side eye a little bit like, we'll talk about that. But they talked a little bit more into how Turtleboy felt when he got out of jail, and they talked a little bit about his case. They talked about how they didn't just fight to provide a defense, but they actually proved her innocence. They talk more about the come down, the fact that they're not avoiding Turtleboy. They talk about that a little bit more, how Karen Reed still texts him. But Turtleboy was clear that Karen Reed doesn't owe him anything for everything that he's done. I mean, the guy's gone to jail surrounding this case. But again, he's like, I own what I do. And from my perspective, I'll live with my own decisions. And Jackson's like, you're a stand-up guy for that. Jackson gives Turtleboy plenty of flowers throughout this interview. No doubt about it. No doubt about if anybody watched this interview, they know the defense is not distancing themselves from Turtleboy, at least from my perspective and how this looks. Then they get into the Brennan effect. I'm going to jump to that.
Sort of the Brennan effect. Look, he had a job to do, but that's shame on that. Shame on that. When you've got lives in your hands, you can't look at this. You can't hide behind the idea. Oh, I'm just doing my job. I just got hired to do my job. No, you didn't. You get hired to dig a ditch or to trim a tree or to unclog a pipe. And by the way, God bless those folks that do that. I used to do that. I was in the military and I mop floors. I mop the best goddamn floors on the planet.
You're a decorated dude.
Ish.
Okay.
Yeah.
All right.
Yeah. I served in the military, but I never looked for accolades. There are others who have given their lives and given life and limb far broader than I have. All I'm saying is you can't just hide behind the idea if you're a Hank Brennan or even an Adam Lally or a Laura McLaughlin, by the way.
What do you think? Why are you saying that? Why
So he's going to get into now them just doing their job versus, they did it wrong. They do have a job to do, like digging a trench, or unclogging a drain or pipe or whatever it is that he said. But I feel like they do have a job to do. They just did it wrong. Like the job of a prosecutor. And he's going to talk about that in his experience as a prosecutor. But to say I'm doing my job, it's like, that's fine. Then do the job right. If you're going to do your job, do the job right. There's a couple things that have popped in here I'm going to look at real quick. Welcome back, Peter. We missed you. You and Papa T thought that the Karen Reed trial would positively impact Hank's career. Now that it's over, do you think the same? So publicly, people don't like him, right? Obviously, people are going to talk about him. Just tell you, in the past, when lawyers get high-profile cases, win or lose, a lot of times that raises their profile and does make people more interested in hiring them. Obviously, I don't know. I'm not going to see Hank Brennan's client list or who hires him or who doesn't. Ashley said, mom's jury trial is over. Guilty ×2 aggravated M with other charges. Got it done in one day. Jury stayed till 9:30 p.m. Defense claimed it was self-defense. Jury of 12, 1 man, 11 women. Wow. So many interesting parts about that. They got that done that quick on a self-defense claim. That's wild. Pita, do you think they added DUI so they would have something to convict on, hence interview admitting drinking versus higher charges? Welcome back. I don't know if that was their plan in theory. It didn't sound like that. Jackson's going to talk about those interviews here a little bit later on. But I definitely think they added it so that if the facts prove that, they could convict on it and they could see the difference between maybe this is how you prove a crime and you definitely didn't prove all of these. John said, great interview, but lost respect for Turtle when after he doxed kids for profit, shamelessly breaching SPJ society. of professional journalism, ethical standards of accountability, privacy, and harm avoidance. He became obsessed. So I don't know. I have no idea about, these allegations or other allegations. I've only read a couple Bettero letters when it comes to this case. Some people have asked to cover his case. I have to look at it more if I'm going to. I have no idea what the timeline is. If there's going to be a trial, I will absolutely jump in and cover the trial. No doubt about it. If that trial were to come, I don't know if I'm going to be able to actually look into all the things that have already happened in the case and jump in and try to catch up that way. Just because we have a couple other cases again that are on in the background here. You mentioned Aaron Spencer. That is one I'm starting to look into. Before, are you still going to look into that case? Although I don't believe a jury would convict him. You never know. Yeah, I mean, if prosecutors are willing to prosecute and cops are willing to say he committed a crime, then there are going to be some jurors that might convict him. Like that. That's just how it is. That's kind of the difficult part of it, is that is how it is. And again, John, I respect you, bud. I appreciate you. I have no idea what those allegations are that you said. I'm not saying that happened. I don't know that happened. So, I got to be careful about what I say on here too. And I haven't seen anything as far as any legitimate allegations with a lot of the people involved in this case. People were telling me somebody pled to something the other day. I didn't see that. So it's like, okay, I'll take your word for it. But, around all of this, it's very difficult because a lot of people are saying a lot of things. So we're trying to focus on this interview and what we learned from Jackson here.
And finish my point. I'll get to that and say, well, I'm just doing a job. No, you're not doing a job. You're affecting a life. You're affecting many lives. You're affecting many, many lives. Look behind you in the view that you've got behind you right now. Those are the lives that you're affecting. Knock it off. Stop being a little wimp and acting like this is just a job and no big deal. I'm just going to go on to my next job. If that's the case, God help us in the judicial system. God help us. You have a broader responsibility, not just to do a job, do the right goddamn thing. Do the right thing. Do the right thing. I did when I was a prosecutor. Every single time I did the right thing. People have asked me as a prosecutor, "Oh, do you ever lament the idea that you might have convicted an innocent person?" No, I didn't, because I did the right thing. I knew what the evidence was. I knew exactly what I was doing before I ever walked into a courtroom. I never ever had to lose a wink of sleep with the idea that I got it wrong. How could these folks, the Laura McLaughlins and the Adam Lalleys and the Hank Brennans, ever sleep at night thinking they got this right?
So let me ask you that then. Do you think that Hank Brennan, Adam Lalley, and Laura McLaughlin truly believe Karen Read did this?
You'd have to ask
before he answers. That's like the only explanation that makes any sense, unless they're completely sadistic people. And some people may believe the latter, that they are completely sadistic people. But it's wild to think if they knew she was innocent or they knew that they couldn't prove it and they still went forward. It is hard to believe how somebody would get there, right? But let's hear what he says.
them. And of course,
but what do you think?
They'll never tell. I have no idea. In my mind, if they're real legal analysts, not a single one of them think that she did this. Not a single one of them. If they're real legal analysts, they're looking at the same evidence I'm looking at. As a matter of fact, I suspect they're probably looking at more evidence than I saw, which is unconstitutional. But
yes, it sounds like it.
Yeah, I have no reason to believe that they didn't have additional evidence that I never got, that I never saw, that I was never able to analyze. But you're dealing with Buchanan, and you're dealing with Tully, and you're dealing with Proctor, and these folks who are bent. They're just bent. Every one of them are bent. So could they go to sleep at night thinking to themselves after analyzing the same evidence that I analyzed and say, yeah, I think she hit him? Really? Really?
Do you think they would have slept well if Karen was convicted?
Oh, all of them.
You
like
think
a baby. So? Like a baby.
You don't think it would weigh on any of them? Really?
No, it's a mental disability. They will think of themselves as, I'm just doing the job of the prosecutor. I put on the best case that I possibly could, and the jury convicted, and I'm gonna sleep like a baby because it wasn't my decision. No, it is your decision. You need to own it, folks. And I don't think a single person in that courtroom was willing to do that. I don't think a single person in that courtroom has been taught the efficacy of owning your own decisions.
Really? Very interesting.
Well, and that's really funny that we're watching this after we watched Lally up on the stand and how they do things in that office and how the district attorney's office works there. And it's just not like a lot of other offices, I'll just say.
So I wrote down some questions here that I have for you. And the first one that, first of all, big supporter. Okay. But I am going to bring one up here.
This is it. He's like big supporter, but he's about to disagree with something that he did. I like it. It's like a compliment sandwich.
That I have for you. And the first one that, first of all, big supporter. Okay. But I am going to bring one up here that I don't understand this one. Okay. When you cross-examined Lieutenant O'Hara, okay, and he said that the CERT team got there at 5:21 and they start digging and then they don't find anything. And then 3 unknown dudes show up. Canton police, he thinks, whatever. Right. And then taillight appears. How come it was never asked who found the taillight and why aren't they on the stand? to this day, we don't know which person in the CERT team found the taillight, correct? We don't know the name of them.
That's right. So that was, like I said, there's very little that's not by design. In that specific situation, he was willing to say, O'Hara, and I've got no beef with him. I honestly have no.
Yeah, I thought he was okay. I don't think he was corrupt.
I actually like that both of them, Turtleboy and Jackson, were like, I have no beef with him. I don't think he was corrupt, because not every cop involved do they take the same shots at. And I think that's really important as well. And that's also something I felt differently about with trial number 1 and trial number 2. Trial number 1, it kind of felt like everybody was included in this conspiracy. Trial number 2, I did not feel that way, that they were really coming at every single person.
He's a fine officer. No, he's a fine officer.
Yeah.
I call it like I see it. My sense was he probably didn't know, because there's 8 guys walking a grid and someone barks out, hey, come over here, or bring a flashlight, or such and such, whatever. I don't think he probably knew. And I wasn't willing to go down that rabbit hole and try to figure out who knew, because I didn't care. At that point, I didn't care. All I cared about was timing. I cared about the timing at which the first taillight piece was found, which was well after Proctor had that car in his custody and had access to 34 Fairview. And number 2, I cared about who actually recovered the pieces and who photographed them. And those were Tully. That's all I wanted the jurors to think about. I did not want to.
So this is an answer that what he's saying is, as a lawyer, you can't get into every little bit of minutia that everybody in the background that's been obsessing over this case and knows every detail about this case. You have to focus on some of the big topics. And he said, just about everything was done by design. So basically, he did not ask that question. He did not dig into that gray areas. How is that possible that we don't know who picked it up? Because he knew what the answers were going to be, and he did not feel they were going to be helpful enough. So he had to kind of pick and choose his battles and what he was going to do.
Every word I say and every question I ask, jurors hang on, right? I'm a defense attorney. So they're like, oh, there must be a reason why you're asking that. Let's say I called into question one of the other CERT team officers, and I had all their names on the top of my head at the time. I could have just barked off, was it this guy, this guy, this guy, this guy, this guy? Then the jurors are going to start thinking, well, wait, was he part of some weird thing that was in conjunction with Proctor and Tully and the others? And I didn't want to do that. So I thought it was a cleaner way to cross-examine, simply by saying, what was the time frame? It was after Proctor had the taillight in his possession, and you didn't pick it up. You never touched it. You never physically moved it.
O'Hara.
All told, O'Hara never.
Yeah, okay, yeah.
All he said was, I see it over there. Detective Tully, you go take care of it. I'm going to continue searching. And that's all I cared about. And I thought that was, in my view, that was the most effective way to deal with the CERT team, which was relatively unassailable.
They were. Yeah. I mean, that was the problem, is they sounded legit.
Which is good for them, that the CERT team was unassailable, meaning they did their job, because then it makes it even harder to explain, like, why did you find all this stuff after the CERT team, who did a good job, didn't find it?
Until those 3 unknown dudes showed up.
Right. And I get to say whoever those unknown dudes are that I want to. O'Hara was, he pushed a little further by saying in trial, which you heard, well, I recognize that none of them were Proctor.
Mm-hmm.
Right. Yeah.
By the way, you hear Jackson say, I get to say whoever I want those 3 dudes are. That's how defense attorneys look at situations like this. If you're not going to tell me who it was, there's 3 unknown dudes, that gives me latitude to say, I know who it was. It's this person, that person, the other. Well, he did cut out a little bit where he said he knew it wasn't Proctor. So you're thinking about how defense attorneys look at vague comments, at unknowns, right? Defense attorneys see unknowns as, I get to make them knowns. I get to fill in those blanks. I get to argue who I believe those people are.
He said they were Canton police. The way you said it, do you think one of them was Proctor?
One was Canton police and 2 were Massachusetts State Police, but he wasn't sure who they were, but they weren't Proctor.
Okay. Do you think Proctor was there?
Yep.
You do?
I do.
Oh.
That's just my opinion.
Okay.
I mean, the evidence is the evidence, but I think Proctor was there.
All right. And
at some point,
so
I don't think that he missed the opportunity to go to 34 Fairview.
So let's talk about the ghost of the Canton Police Sallyport. The guy that there's a 20-second gap there at 536 to 537. Some guy, footage disappears, and all of a sudden, some guy comes from where Proctor's standing and walks out. I think that was Ken Berkowitz. Who do you think that was?
If I had to guess, I think it was Ken Berkowitz.
Okay.
He's short in stature. Ken Berkowitz was short in stature. He just appeared out of nowhere. I have other information. We had other information which we propounded at trial that Ken Berkowitz was in and around the Sallyport that night. Later that night, he had access to it. He's the chief of police. Even though he might have been IOD at the time, he still could come and go as he pleases. And in a situation like this, where there's a police officer found dead on another police officer's lawn, especially Brian Albert's lawn, whom he knew well, there's almost no chance that Ken Berkowitz was not in some way, shape, form, or fashion involved in the goings on in the subsequent 8, 10, 12 hours.
I mean, you would have to be. I mean, that's Higgins' best buddy. And my question is, I understand he was obviously not alive for the second trial. Did you guys try to call him during the first trial? And I understood he was very sick during the first trial. Did you want to call him, and were you allowed to if you were?
If we wanted to, we probably could have. It was not high on my priority list. I didn't really want to hear from Chief Berkowitz. I know, look, he's a seasoned officer. He was also Brian Higgins' best friend. I tend to evaluate the folks that we call in terms of the pros and cons. I didn't feel like the pros outweighed the cons of calling him in the first trial, even if he was available. So we didn't even really try.
Okay. All right.
And again, this is a lot more trial strategy. Did you call this witness or not? Why didn't you ask about this? How did you handle this piece of evidence? Than we have gotten from anybody else that I've seen, I will say. So I appreciate this. These are the types of conversations that I value the most, where it's like with a trial lawyer about a trial you just did that everybody watched and hung on every word that you said, just like he said. Why did you do this? Why didn't you do that? Why did you call this witness? Why didn't you call that witness? There are certain things that he says, I can't talk about this or can't talk about that. But the vast majority is, I feel like we get to see a lot behind the curtain here in this interview. Peter, so excited to catch my first live since vacation. Hope you had a great trip and can't wait to hear your opinion on Kohberger sentencing. I needed to just literally take a little break from Kohberger. That was absolutely brutal. I'm not very emotional person, not easily emotional, but hearing the parents talk about their kids as someone with 2 kids, it's brutal. It's like impossible to get through. So I'm going to figure out a way to pull some clips and talk about the legal side of sentencing, the purpose of victim impact, the different types of victim impact statements, some of the arguments the lawyers made or didn't make and why, and what the judge said and where the leeway is. I'm going to try to take it from that angle. And I think we'll talk about Kohberger's sentencing tomorrow.
So I have some other questions here. The next one is so I talked to Karen right during, like, when the prosecution was wrapping up its case, and I'm like, it appears that Proctor wasn't going to be called and McAlbert's weren't going to be called. And she asked me, do you think that we should call him? And I'm like, you're asking me? I'm not a lawyer. I'm like, yeah, I think, yeah, totally. Yeah. How can you not call them? Like, that'd be horrible if you don't call them. Ultimately, you didn't call him. And tell me, was there any dissent on the legal defense team about that?
So they didn't call Proctor and Higgins, among other people. How could you not call him? Karen Reed asked Turtleboy, what do you think? Should I call him? He says, absolutely. I'm not a lawyer, but absolutely you should call him. I found that to be incredibly interesting, right? Like, so interesting, the stuff that happens in these high profile trials. Now, I will tell you from experience here, it's different. Just everything's different now. The communications that are happening, the research that's being done, the stuff that's happening online, these high profile trials are different than they've ever been. And a lot of what happened in this interview is evidence of that. So he's like, what were you thinking? What a big mistake. I think at this point, you've caught the vibe of the interview. You know where Alan Jackson's going to go with his answer, but let's take a listen.
There a rigorous debate about whether or not Proctor and the McAlberts would be called?
Not really. Not really. I mean, there was a debate, not a debate. There was a discussion. That's a better word for it. Not a debate. It was a discussion. Ultimately, the buck stops with me. It was my decision not to call Michael Proctor, who's my witness, as lead counsel for the Commonwealth versus Karen Reed. Someone's got to make the ultimate decision. There was no real dissension. Once we talked it out, it was my determination that it was not in our best interest to call Michael Proctor, not because it wouldn't be fun. Not because I wasn't ready for it, not because it wouldn't be a lot of fireworks. And that's why most of the media was, and the internet went nuts. And, oh my God, you got to call Michael Proctor, because it's entertainment, for Christ's sake. You saw the first trial?
It is entertainment, but Betterow, a man I know you respect a lot, was pretty vocal that he would call Higgins, especially. He was
deeply respect Betterow. I heard that thrown in there. That was awesome to hear, right? I'm sure Betterow liked that. He said he deeply respects Betterow, who was like, I'm calling everybody. Betterow was literally like, I'm calling everybody. When he and I had our discussion, I was like, I'm definitely calling Proctor. I might be able to be talked into calling Higgins. That's it. Betterow was like, I'm calling this person, and here's all the reasons why. Jackson's like, nope, we're not calling anybody. And the buck stops with me. So if it's a screw up, then it's on me. That's how Jackson was taking it, which respect, right? At this point, it was right. You won, right? It was right. I still think they would have won if they called Proctor. But again, revisionist history, you don't need to look back on it and think, what if?
It's like, he just thought there was a lot left on the table. And by not calling him, and I said this on my show, I go, this is the ballsiest decision ever, because if this woman is convicted of anything,
I gotta own it.
Then you not only got to own it, that's going to go down as the worst call ever. Like, you're Grady Little, like level, like keeping Pedro in the game. Like that's what that would go down as. Didn't that make you freaking nervous?
I I say this a lot, and it sounds really self-aggrandizing. I don't get nervous. I make people nervous. I make decisions because they're the right decisions, and it comes from 30 plus years of decision making. And at some point, you got to have the balls to make the call. You got to make the call. I knew that in my heart of hearts, I knew that having an empty chair, having the ogre under the bridge, and that's both Proctor and Higgins. I could make hay out of the fact that the Commonwealth didn't call two very, very obvious witnesses. How do you not call as the prosecution? How does Hank Brennan sit there with his suit on and his tie knotted and his glasses on, sitting there with his hair combed and his socks and his shoes and all his accoutrements, and stand up in front of the jury in closing argument and express to them a reasonable judgment why he didn't call the lead homicide investigator for the lead homicide that the jurors are expected to judge?
Well,
and I made him.
He wasn't the lead. He wasn't the lead, according to Mr. Bukaki.
Yeah. And everybody in the courtime except him knew that was bullshit. That was complete bullshit.
I would say including him. Everybody in that courtroom, including him, knew that. Hi, Peter. Jackson is newly representing a young guy in LA, Frazier Michael Bohm. Would you consider following that case? Is that like the car accident case? I heard a little bit about that. Some people asked, let me know if there's like hearings or things happening that, I can jump in and cover and react to. That would be great. Let me know if you guys are interested in it. You know what to do. Unpopular opinion. I thought her interviews helped her more than hurt her. It showed she wasn't trying to hide anything, including her drinking. Can agree to disagree, right? But you got Alan Jackson on your side. Just wait till you hear what he says about her interviews. One of the victims was videoing the whole thing, and it showed him it to both her husband and her. I don't know exactly where this is coming from or when this was posted. I'm not sure what the context is here.
So I was never going to, my decision at the very beginning of the trial is if they don't call Proctor, I'm not going to call Proctor.
Really? So you decided early on?
Yeah, I was going to make them own it. They're going to own it.
Okay.
They're going to have to own that. And it's a difficult ownership to have, not to call your leading.
Which actually makes sense. If you think about the opening statements of both trials, it always felt like they were trying to bait the Commonwealth to call Proctor. And they did call Proctor. So obviously they crossed Proctor in trial number 1. They didn't call him in trial number 2. And so the bait, was kind of working that they're like, haha, look, we said they wouldn't call him and they didn't call him. So it's like, I get where he's coming from. Again, I don't necessarily agree with it, but we always have to remember they know so much more about this case. And that defense team met, they discussed, they did not debate, they discussed it, and they all determined and got on the same page to not call him. So we got to trust that they know more. It's their case, they're in the background, and they're doing the best, what they think is best for their client.
Investigator, when the jurors are commissioned with the responsibility of judging the investigation. How do you not call the investigator? So I knew what I was doing. But
you destroyed him last time.
I did. I didn't need to do it again this time, as the evidence indicates, right? We got her acquitted, right? So
you did.
I knew that I didn't need to. From an ego standpoint,
and that's the end all be all. She's acquitted. So it's tough to ask questions or really push back too much. I think Turtleboy did do a good job of doing it and picking his spot. You don't want to have somebody on your show and interview them and just be a jerk and fight with them and argue with them the whole time, right? But you want to say what you actually think and you believe about the trial and where you think some of the issues were, if they'll let you get into the details of the trial like Alan Jackson was okay with.
Case, right? We got her acquitted, right? So
you did.
I knew that I didn't need to. From an ego standpoint, I would have loved to cross-examine Michael Proctor again. He stood no chance. As bad as it went for him the last time, it would have gone 10 times worse this time.
He had so much more, including his termination. Like, I agree, it was going to be 10 times worse, which is why I wish they would have called him. Not for entertainment's sake, because I think it would have, if Kelly Dever drove anything home, Michael Proctor would have taken it all the way. This piggy goes all the way to the market or whatever, or we all the way home. It's just par for the course, me screwing that up.
I didn't need it. It's not about me. It's not about me having, national press cross-examining some lead investigator who's falling apart under the crucible of cross-examination, having to answer for questions, having to answer for text messages that he sent that are disastrous for him. That's not what it's about. It's about trial strategy. And that's what I employed. And Karen agreed. And at the end of the day, it was, like you said, the buck stopped with me, but everybody on the team agreed. Nope, we're not calling Proctor and we're not calling Higgins.
Let's talk about strategy for a moment. So I went through some old messages with your client from like November or October of last year between the trials. And one of the things I'm telling her is you guys have to call Barros. You guys left it on the table in the first trial, not asking him that question that you asked him this time.
Stop it. You didn't leave it on the table.
I know.
Jackson's not going to give an inch. He's like, we did nothing wrong in this trial. We did not leave it on the table. We didn't know about it. It's just so funny to hear. This is a guy. So we talk about this all the time. You have these cases and you believe it. right? You make a way better argument when you actually believe your argument and you actually believe what you're saying. It's a lot harder to sit here and argue with somebody like Turtleboy about all the details of the case and everything that you did and every strategy decision you made if you don't actually believe it. But when you believe it, you're going to push back on everything. And that's what I feel like he did throughout this entire interview.
Didn't know the information. They hit.
You asked him this time.
Stop it. You didn't leave it on the table.
I know.
You didn't know the information. They hid the freaking information from us.
Well, no, but you didn't know what he was going to say. I'm talking about
exactly.
Right. So they did hide that information, right? Cool.
Yeah.
So my question for you is, because I'm like reading these messages, and she's like, telling me here that we got what we wanted. You have to walk away. Never ask one question too many is Alan's MO. It's too much of a risk. Blah 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 blah. And I'm sitting here and I'm telling you,
it's like mock trial 101, right? Don't ask one too many questions. Don't ask questions you don't know the answer to. And he subscribes to all of that. And there's a reason they teach it in every mock trial class, right?
That guy wants to talk. I could tell just by the way he said it. Yeah, that guy wants to talk.
A good instinct, dude.
So how did the Barrows connection develop? Like, is my question. Did you guys reach out to him? Did he reach out to you? Okay.
No, we reached out to him through a subpoena. And then the normal process is a defense attorney, even in Massachusetts. I mean, same in California. I send a subpoena out. If it's to law enforcement, their subpoena control office sends the subpoena to the officer. Usually the officer will call us back. I think he did. I think Nick called us back and said, hey, look, when do you need me? When are you thinking the trial's going to go forward? It's just logistical conversations. And I said to him, as I would with any witness in that position, I would like to meet you face to face. I just want to, and the reason for that, Aiden, is because I wanted to kick the tires, right? I don't want to put a witness on, especially with the import of information that Nick Barrows had, without at least hearing a little bit of his countenance. How does he carry himself? What are his, and by the way, it wasn't.
And what's he going to say about the taillight?
It wasn't going to be a deep conversation about the taillight. I wasn't going to ask him deeply about the taillight. And I didn't.
No.
So when we're in the hotel, come over to the hotel.
So this is also, he's got to be careful because he had a conversation with the judge about what conversations did you have or did you not have with Nick Barrows? And he's saying, no, just logistics, but I also want to be careful about what I ask. It's kind of a little bit of a cryptic answer here.
Let me meet. He said, sure, I'll drive. I can do that. No problem. So we met at the hotel. We talked about logistics. We talked about when he's available, how long his testimony is expected to be, et cetera. And I had, some of this I'm going to leave for other forums.
Of course.
So there was a decision that I had made. Karen was well aware of it. Liza was well aware of it. That it was going to be a game time decision about how that interview was going to go. And I'm allowed to ask anything I want to. I could show him all the photographs I want. I could show him his prior testimony. I could hand him his transcript of his prior testimony. I can do anything I want.
There'd be nothing wrong with that at all.
Anything the Commonwealth could do, I could do. But I made a decision at that time, and we'll talk a little bit more in different forums about this.
So that's where it was, right? We'll talk a little more about this in different forums. Is that a movie? Is that a book? What are we picking up on there? Is Barrows going to be a main character here? I thought that was interesting. It's like that's what we're going to get on that.
Why I handled that interview the way that I did. And by the end of the interview, I was, and it wasn't an interview other than just the logistics, really just.
I mean, is it an interview if it's just the logistics, right? If you're just like, how long are you going to testify? Are you going to go here, there? How do we drive? How do we get you there? Logistics. Is it really an interview? I'm interested in this other forum where we're going to get more information on this.
When can you be there? How do I get a hold of you? Do you have a cell phone? Do I need to go through subpoena control? Here's when we're thinking about calling you. I don't know if the Commonwealth's going to call you or not. Did they subpoena you? I asked them that, et cetera. Nope. They weren't interested in him.
They didn't put him on the list.
They didn't even put him on the list. And that tells you everything you need to know about whether Hank Brennan and the prosecution was after the truth.
They put me on the list and not Barrows.
Correct.
Which tells you a lot.
They put you on the list. If I had to guess, they put you on the list to get you out of the courtroom. That's why
he was never going to call me.
It was horseshit. Are you kidding? You're going to call Aiden Kearney in the case of Commonwealth versus Karen Reed? Not a chance.
So I actually was the one that informed you last June during the first trial that you had no idea that Karen Reed was almost indicted, or not. We don't know how close she was, but there was a grand jury that took place into conspiracy to commit witness intimidation. You found that out when I told you that, right? You didn't have no idea that was going on.
Zero.
How do you feel about that?
I felt backstabbed. I felt jumped. I felt like it was just another opportunity for the Commonwealth to put their foot on Karen's throat. They were never, ever, ever going to be satisfied until she was behind bars, in handcuffs. By the way, I think that this was a ploy. If I had to guess strategically as a prosecutor, I think that this was a ploy to get her bail revoked. I think they wanted to try this case with her in Orange County jump, an Orange County jump. Period. Full stop.
She's a lot less effective behind bars with no internet.
Oh my God. I mean, we could not.
Isn't that crazy though, that Turtleboy gets this information and gives it to the defense attorneys? Because everybody was like, oh, defense attorneys are feeding Turtleboy information. And maybe that was true. Maybe that did happen. I have no idea. But he told the defense attorneys a lot of things, or told Karen Reed a lot of things that made their way into the trial or into the assessment and the work they were doing. It's wild. It's really wild.
I've said this before in other interviews before the trial, that I've never, ever, and I don't know that I ever will, find a smarter client than Karen. She is just brilliant. You've had a lot of interaction with her.
She's very
You've talked
smart.
to her several times. She's very smart. She's got an encyclopedic memory. She can pull things out of her head that, I mean, if I asked her if I called her on the phone right now, no, I'm not going to, tell me about this report, she could say, without looking up anything, she could say that was in the such and such report on page 273. I remember it was sort of the top half of the page, and the person said X. Literally that level of knowledge about the entire case. Tens of thousands of pages worth of data. If I didn't have access to her, if Liza didn't have access to her, and Bob and David didn't have access to her, we would not have been an effective defense team.
Calling her on the secure staff every day wouldn't have been fun.
They knew that. Yeah. Brendan watched the first trial. He's not stupid.
No,
he may be a lot of things, and I've got a lot of adjectives for him.
But he's not stupid. A lot of adjectives for him, but he's not stupid.
But he ain't stupid. And saw how effective she was. He wanted her behind bars, period. And they used Cosgrove or whatever that.
Mello.
Yeah. Mello, whatever. They used him as a tool.
So that was actually one of my other questions I have written down here. So in January of 2024, when I was locked up, I saw in the news that your client's home was raided by the state police, and that they had been monitoring her trips to Florida, and that they had a warrant for her phone. And it was all related to potential conspiracy with me. And when it first happened, I'm like, oh man, Ken Mello really opened up a can he doesn't want to hear, and they're gonna like destroy him. But you guys really didn't go after Ken Mello. You really didn't talk much about that. Why was that?
Wasn't relevant. If it didn't go anywhere, if it didn't go to an indictment, then I didn't care. That's just bullshit. It's just fodder. It's cannon fodder that we didn't care about. I didn't want to get distracted with that issue if it wasn't going to lead to an indictment, and we learned that it wasn't. That it was a failed attempt. So why bring Ken Mello or Cosgrove or anybody else that's going after you into her orbit? It just wasn't necessary.
Okay.
And that's exactly the decisions that lawyers make. I agree with him. Like, there's a million ways you can try to make people look bad and shady, but how relevant is it to what you're actually trying to accomplish? Silver, can you look into Arizona v. Javier Lopez, August 12th through 20th? I will look at that. I think that might be the same time as the Adelson trial, though. AJ will say, as a prosecutor, he did 100% right. As an advocate for wrongfully convicted people, I don't 100% believe him, even though AJ is brilliant. Here's what I'll say. What you have put in here twice is, actually, you said AJ will say that he did it absolutely right, and you say you don't believe him. Both of those things are subjective. And I will say good prosecutors should believe that they didn't wrongfully convict anybody, that they didn't go forward on a case that they didn't think they could win on, or that they didn't think the person was actually guilty on. So that is what a good prosecutor should believe. But I get where you're coming from, that there's still, a chance that somebody was wrongfully convicted, that there was somebody that was truly innocent, that Alan Jackson thought was guilty, maybe even proved he was guilty legally. It still does happen. So I get where you're coming from.
Next question. Do you regret not advising Karen Reed to avoid media interviews? Because they were used against her a lot, and I know it wasn't really effective, but it must have been a pain in the ass and a distraction, was it not?
I don't regret one bit, not one frame of interviews that Karen
really
did.
Interesting.
Absolutely, I do not regret one bit of it. Every time they played an interview, I just went like this.
Those didn't bother you at all, like none of them.
How about that? I'm gonna back it up so we can hear it again. He doesn't regret one bit of Karen Reed's interviews. And in fact, every time they played it, he was rubbing his hands together. That's mind-boggling to me. I don't get it. I totally disagree. I don't remember anybody on the jury being like, wow, those interviews were really good for Karen Reed. Maybe he means like, yes, they're just going to convict her on DUI. I don't know. Nobody really in the public watching this case thought they were good. Everybody that was in the comments, in the chats, not just lawyers, I'm talking lay people that could be jurors. Everybody was like, ooh, that's not good for this reason or that reason. He explains kind of why. And even after his explanation as to why he thinks the interviews were good, or not even just not bad for them, but actually good for them, he didn't pull me there, right? That's still a disagreement. I still disagree on Proctor. I totally get where he's coming from. And again, this is not me saying I'm better or smarter. It's like these caveats you have to have. If Alan Jackson was here right now, he'd have no beef with somebody disagreeing with him, right? He would stand strong in his position. I have no doubt about that. But I still just fully disagree about these interviews, even after this explanation. But let's hear his explanation.
In a distraction, was it not?
I don't regret one bit, not one frame of interviews that Karen
Really?
did.
Interesting.
Absolutely. I do not regret one bit of it. Every time they played an interview,
I think it's absolutely hilarious too. No, I'll just tell you right now, I was thinking that might be you reading into certain things. Go watch back. My dad said they were absolutely horrible. He cannot believe how they allowed her to have these interviews over and over again. He does not think those interviews were a good idea. I do think it's hilarious how a ton of people in the chat now are like, oh, I thought those interviews were great. I thought they were so good. It's like, okay, either maybe you always believe that. Maybe Alan Jackson convinced you. Either way is fine with me. I still stand by they were not good in my opinion. But again, they won. So they can tell me I'm wrong and they were right all day long because they won. They got the just result.
I just went like this.
Those didn't bother you at all. Like
do
none
it.
of them.
Do it as long as it's in context. You know, if they take one sentence out of context,
But they weren't. They felt so out of context and clipped up.
then I've got an issue with it. And they tried to do that several times. I think
Every time.
pretty much. And we were able to expand on the context where necessary. But
you didn't expand on the context. Like for instance, the one where she says that, hey, Jen, it's either me or you.
I agree with Turtleboy. I don't think they expanded on the context. Everybody was waiting. I thought it was a good idea to not bring them back up. They were so long ago. Why play them to try to build context? Don't let the jury hear them again. And by the way, if they were so great, could have played them in front of the jury again, right? If they were so great for your side, why not play them during your closing argument? If you're rubbing your hands together and they were so great, play them in your closing argument. Let the jury hear what's so great about these interviews. I think they handled them appropriately and they made the right decisions by not replaying them, not, adding context by playing more of the videos. I thought they did handle that well and they dealt with them appropriately, but it didn't feel like a hand rubbing together moment for me. But again, it's just my position.
Necessary. But
you didn't expand on the context. Like for instance, the one where she says that, hey, Jen, it's either me or you. It's my understanding that the larger context of that was that Karen was asked, who do you dislike more, Michael Proctor or Jennifer McCabe? And she said that I actually kind of understand. She goes, it's Michael Proctor because I kind of understood where Jen was coming from because it's either me or you, Jen. But Michael Proctor did this he didn't have to do this, right? And
right.
How come you didn't play that whole clip? Were you allowed to?
We would have been allowed to. We didn't need the entire clip. I didn't think the Jen McCabe me or you issue was that grave. There was extra context that was, I can't remember exactly how we got it in, if it was through a transcript or through a tape. But we were able to lay context to that. It didn't matter. I didn't think it mattered. Every time she talked, every time Karen spoke.
And that's fine to say it didn't matter. I get you. And it's also fine, and I agree with him, that the jury hearing her voice took away some of that. We want to hear from the defendant. What does she think? What does she say? Because the jury does feel that in almost every trial, even though you tell them, of course, Fifth Amendment right to remain silent. They don't have to testify. Don't hold it against them. So many do.
It added flesh to the bone. People got to hear her. I think the jurors, I didn't care about the other people, but the jurors got to hear her vocal cadence, her tone and her tenor, her effusiveness about certain things, when she was upset about certain things, when she was sad about certain things, when she teared up about certain things. That was my way of putting her on the witness stand without ever having to put her on the witness stand. And the Commonwealth fell immediately into that trap. That's exactly what I expected that they would do. They would pick and choose certain things, and they would think to themselves, oh, well, I've got this and I've got that. And I'm sitting here thinking, you're making a huge mistake. You're making a big mistake.
Wow,
and ultimately it did.
So let me ask you this. Who do you think did a better job? And they both are losers.
All right. So before they get to who do you think did a better job, there was something I was going to say. And I lost it.
Adam Lally or Hank Brennan? Because I think Adam Lally did a better job.
I do too.
He got 9.
I do too.
Hank got 0.
Yeah, I do too. I think that
they both think Lally did a better job than Brennan. And when we talk about it, he got more wins, right? It's like Brennan had a strategy that just completely didn't work. The way I looked at it, Brennan was definitely better at his presentation, but he was just dead wrong. Lally just kind of threw everything out there. So definitely the proof is in the pudding with what the jurors thought. Adam Lally did a way better job than Hank Brennan.
Adam, I'm not going to speak about personalities, but just in terms of legal prowess, I think Adam probably tried a better case. Hank thought he was, I think Hank thought he was being too cute by half, by being the data guy when the data actually benefits us. I don't think that the Commonwealth knew the data nearly as well as we knew the data. We just knew it. We knew it from the first trial, and we knew it into the second trial, and we knew it better in the second trial than we did in the first trial.
Yeah, and I agree with that. I do agree with that. Why is it wild that Turtleboy gives the info to the defense? Are they not allowed to have outside investigator? Are they supposed to disclose? No, absolutely. There's nothing wrong with that. I'm just saying somebody who's so out there publicly talking about this case every single day, also giving information to the defense and talking to the defendant is just unusual. Like, to me, it's just not something that's very common that happens in these high profile cases, and to be so open about it, right? Have you seen the Barrows interview regarding Lally? I have not. I have not seen that. I understand the timing. The victim in the Lopez trial is my literal sister-in-law. She left him due to DV. He M'd her with my nephew in the car outside. Whoa. Okay, I'll try to take a look at it. The Lopez trial. I'm sorry that happened to I think it's either your sister-in-law or nephew, or your nephew was outside the car. Okay, we're a little over an hour. We still have about, 15-ish minutes left of the interview. So hit that like button if you guys are sticking around for overtime here, because we are going to watch, I think it's almost the end of it, about 15 more minutes of the interview.
So I think ultimately, look, the proof is in the pudding, right?
Yeah.
The jurors in the second trial weren't hanging on hardly anything.
Yeah. Well, what Hank hung his hat on, and what I'll just play devil's advocate, it's really hard because it's really stupid, but their biggest thing was that the texturing data shows that Cameron reversed at 12:31. Do you agree with that data? And were you worried about that at all?
I wasn't. As a matter of fact, I embraced it. You'll remember in my opening statement and in my closing argument, I bookended both of them. We talked about 12/31/38. They bought it. That's what the Commonwealth just bought and owned, that time frame. That came from Welcher. He was absolutely unequivocal about it. The impact occurred, and it's a completely incapacitating impact at 12/31/38. Right. So,
but how do you explain reversing at all around that time?
So I didn't care about that. I think the reversing could have happened on the way home. It could have happened at the.
By the way, another thing that people got really frustrated at me for, and they still do in a lot of these cases, if you notice what Alan Jackson did right there, Turtleboy's like, here's kind of the Commonwealth's best fact. She backed up at 12:31. And the way I think the best way to explain that is, that's great because she connected to John's Wi-Fi at 12:36. It's impossible to drive back to his house in that period of time. He doesn't go there. You know what he says? I didn't care. I didn't care that she backed up at 12:31 because that could have been in the three-point turn, could have been here, could have been there, could have been anywhere. Didn't matter. If I don't have to explain it and prove it, I'm not going to. He says, because John was still alive, is what he says. Because he looked at his phone, checked the text messages, whatever. People have tried to explain, oh, that could happen this way, that way, with the other. Alan Jackson sees it his way, sticks with it his way, only answers the questions and proves the facts and proves the why when he needs to. That's why when it got to conspiracy, I was like, I personally, as I'm looking at this, I don't need to get to conspiracy. If it's not guilty, it's not guilty. She should never be convicted based on the evidence that exists. And that frustrates people when we talk about, well, what did this person do? What did this happen? Lawyers only go as far as they need to go to prove their case and win. And that was an example of it right there by Alan Jackson.
At the three-point turn, there's enough play in that data that there's no way that the Commonwealth could prove beyond any reasonable doubt that the reversing actually occurred in front of 34 Fairview. There was a reversing event at some point, but it could have happened on her way home when she, takes a left and there's some snowplow coming and she decides to reverse, go around a different corner, or go around the snowplow or whatever. Right. Could have been 1,000 things. Could have happened at the three-point turn, which, by the way, is where the Commonwealth originally said it did happen. Then they changed the data. So I didn't really care.
You know why they changed it, by the way. Can't cover up part 73. One of these pink people outside did a video showing that a three-point turn would have broken the left taillight, not the right. And they just immediately abandoned ship after that. They're like, okay, we're going to adjust this. A question a lot of people have, and mine is the X-rays.
Oh, right? By the way, let me answer. Let me finish answering that first question. The reason the 12/31/38 didn't bother me is because John was alive and well after 12/31/38. Period. Amen. I mean, full stop. It's just that's just the data on the phone.
Because he moves in the phone.
No, it's not just because he moves. It's because he picks his cell phone up, he opens it, reads a text, closes it, walks around, and then the phone moves. I mean, there's multiple data points that show that he was alive after the time they said he was reversed into and incapacitated.
But you don't actually believe he was alive. Like you believe he was incapacitated. That means someone else was using the phone, correct?
Someone else was picking up his phone and manipulating his phone.
And didn't they say that? Let me get this straight. Did they say that they did the face recognition to open the phone, which would mean that John was knocked out and they put it up to his unconscious face to open the phone?
Unclear. It's unclear. The phone was definitely opened. It's unclear whether or not it was opened by a biometric or it just happened to be open. But we do know that he checked a text. He checked a text. I think I said that right.
Yeah.
And he read a text that he closed the phone.
Yeah.
Yeah, it was the Jim McCabe text. So there's no question that we know that he was manipulating his phone. He was advancing some interaction with his phone after 12/31/38. So it was done.
Yeah.
It was done.
Can you talk about the garage at all? You guys went heavy on the garage in trial 2. You didn't mention the garage at all in trial 1.
Yeah, this was one of those that was like, we just started hearing about these different things, these different theories, which again just proves the point. They can't prove what happened, which again, I echo what I said so much during the first trial. That's what was so hard about the conspiracy, about him getting beat up and dragged, whatever happened. It was so hard to prove, obviously evidenced by kind of the shift in the defense from trial 1 to trial 2. And they're about to get into it here.
Is that because of the cell phone battery information that would align more with the garage? You went basement heavy in the first trial, garage heavy in the second one.
We knew that the cell phone data was consistent with the garage. It was also consistent with the basement. I mean, as long as it's a cool place, cooler than outside, but not freezing. We knew that data was consistent with either one. But there were data points inside that garage that suggested, that we found out after consulting with certain of our experts, that suggested that there may have been something that happened inside the garage. So
yeah, let's talk brass tacks. Let's just get down to it. What do you think happened to John O'Keefe? Tell me your theory.
I'm gonna leave that to a different time and place.
Okay.
I think that's gonna be movie, TV show, book, whatever. But it's like Turtleboy asked the question. It would be great to hear his response, but he's gonna save that.
Do I have a theory? Sure, I have a theory. But I think the important thing for your audience is that's the beauty of this, is that every single bit of this data played out in open court. I mean, some of it was attempted to be hidden by the prosecution. Some of it was attempted to be hidden by the judge, which is shameful. But the real data got played out in open court. People can make their own decisions. I guarantee you have a thought about what happened. What do you think happened?
I mean, what I think happened is, I think that, see, the garage is hard because the garage is not connected to the house. You would have to go, if he went in the house at all, that means you would have to go back outside and into the garage if it happened in there. And are they just sitting in there waiting in the garage? I think a fight happened inside the house and they moved his body to the garage. I think that's what happened, is because, you got a guy bleeding in there. You got to put him in, you got to get him out of the house. You can't have, that's what I think happened.
I'll tell you what absolutely unequivocally happened. He didn't get hit by a car.
He did not get hit by a car. And that's the only thing. And you did go heavy in the first trial.
And guess what? That's like exactly the difference between the first trial and the second trial. Trying to prove garage, where did this happen? Was there a fight? What's the J on the back of his head? Did he hit a weight bench or weight bar? Guess what? You know what we're all positive about? He didn't get hit by a car. And I think that whether everything was perfect and it was the best defense ever, best defense lawyers, dream team, handled everything perfectly, made all the right calls, the shift in strategy from trial 1 to trial 2 will go down in history as one of the best shifts ever, because usually retrials are very similar. This one was anything but.
You kind of seemed like you wanted to solve the mystery of who killed John O'Keefe. Do you think you did go heavy in the first trial? You kind of seemed like you wanted to solve the mystery of who killed John O'Keefe. Do you think, looking back at that, obviously you didn't do that in the second trial. Do you think that was a harder pill for the jury to swallow in the first trial? Because it was like they had to believe your theory or the Commonwealth's, and they were like,
Right. So there's, I mean, look, one of the things that you have to do as a trial lawyer, as a professional in any particular, is learn, and as you move forward, learn from your prior conduct, learn from your prior experiences. One of the things that we were very, very focused on in the second trial was establishing that we did not have a burden. We did not have
boom. Because the first trial, it really felt like they took on a burden. We talked about that from the jump in opening statements when I knew nothing about this case. That's exactly what it felt like the first trial, and they made an epic change for the second trial. That was just kudos to them for it.
Any burden to prove what happened.
Mm-hmm.
The case rises and falls on whether or not the Commonwealth can prove their case beyond a reasonable doubt. And so I shifted in my opening and my closing to reasonable doubt, because that was something that I felt like we could do better. It wasn't necessarily a criticism of the first trial. It's just something that we could do better. Make sure that the jurors aren't shifting the burden to us to solve the crime, to prove what actually happened.
Mm-hmm.
Let's keep the burden where it belongs, which is reasonable doubt. And that's why we built the closing argument the way that we did, which is stacking the reasonable doubt cards sort of proverbially on a table over and over and over, just overwhelming the jurors with reasonable doubt.
Did you hear? I know you're probably so busy during the trial, so you didn't watch my show as much as you guys used to. And there's also lots of other channels too to get your content from. But I specifically did a whole show on Jose Baez closings. And specifically, he loves to do these big boards of reasonable doubt. And I'm like, I go, Alan Jackson, if you're watching, you got to do the reasonable doubt big board. And then lo and behold, you had a reasonable doubt big board. Did you?
I wish I could say that I saw it. I didn't. I was, as you indicated, I was busy. It makes sense. It makes sense that somebody like Jose, who's a fabulous trial lawyer, would do something like that. Obviously, we came to that honestly on our own. It was a decision that I.
It's like the most common argument for defense lawyers, right? Different ways to explain all this reasonable doubt. The top 10 reasonable doubts, a stack of note cards, reasonable doubt, a big board of reasonable doubts, way too many reasonable doubts. It makes this verdict unreasonable if it's guilty. However you cut it up, it is such a used strategy because it's correct. It's legally correct. It's how our justice system is built. That's why so many good trial lawyers find different ways, their own ways of explaining and trying to get the jury to understand what is reasonable doubt and how much of it exists in each case.
Actually, I was sitting in my hotel room and I was writing out cards, physical note cards, just because it's how I think. I did it in my first closing argument to coordinate what my thought processes are in big categories. And ultimately, I decided that I wanted there to be a visual of what I was thinking in my head, in my hotel room as I'm laying these cards down of reasonable doubt. And so I consulted with some very smart folks who could put this thing together. One of whom was Karen Reed, believe it or not.
Okay.
She's very, very good. She's very visual. And I told her what my vision was, and she helped me put together this reasonable doubt.
It was brilliant. They did not show this during the stream.
No, they didn't. One of the things that a very dear friend of mine and yours did for us.
This is Richie from Microdots made this.
Yeah, Richie Keogh. He put together my closing with the big board, with the PowerPoint infused into it, so that the audience can actually see what the closing argument looked like from the perspective of the jurors. And that's now up and running. It's live on my website.
I was watching during your closing some of those jurors, and they couldn't stop looking at the big board, especially like juror 18. A young woman who was ultimately chosen. Juror 16 kept looking at it, the one that looked like Gemma McCabe. And man, let's talk about that jury.
The admiration and flowers they give to I don't know if they're content creators. I don't know what they would be considered, right? The people that were able to put together demonstrative aids, journalists, different people involved that also make content and YouTube videos is really cool because they appreciated it. They validated the work that those people put in and how helpful it was to get these messages out to the public. That was such an important part of this defense. And it's such an important part of so many high profile cases. What does the public think? Lawyers can test. How is this going to go at trial? How is this going to look? Should we talk about a plea deal? What are the options for our client? Do we have a good case? Are they going to believe this argument? Are they going to believe in factual innocence? Right? Which, brings up some stuff we'll talk about tomorrow with the Brian Koberger case. But it was really cool to hear Alan Jackson talk about that.
There was a lot of young people on that jury.
I love that jury.
Yeah, what'd you love about them?
The fact that they were young, smart, attentive, by and large. Compared to me, everybody's young, right? So young, smart, attentive. They were up on the edge of their seat. They were leaning forward. They were on the balls of their feet. They were taking notes where I thought they should be taking notes. Ironically, juror number one, the first juror, the foreperson, didn't take a lot of notes. But from what I hear, that gentleman walked back into the deliberation room and knew this case inside and out. He could recite every single.
Yeah. And we always love the jurors that give us the verdicts we want. So Microdots is who he was talking about. And again, it's one thing for the jury to understand it, but also with how they're doing it, how they were handling this case. And like he said, everything was curated, everything was planned, everything went according to plan. Nothing was by accident. Helping you all understand what they're doing. That was really important. And a lot of you apparently watched Microdots and the things that they were doing. And that's an important part to this defense, right? They care about what the jury is thinking. That's the most important people, but the public was also really, really important to them. All the flowers.
Witness and every piece of evidence in a conversation without ever looking at a note. What a brilliant gentleman that guy is.
He was an impressive guy. That guy
impressive guy.
Shouldn't they say what? That he loves the jury? There's no beef about that. Most lawyers would say the same thing.
And ran the jury beautifully, apparently.
The whole jury was impressive. Like there was 8. First of all, not one of them dropped. Not one of them got sick. Not one of them had a family thing. Or any. That's amazing in and of itself. They all showed up every day. Not one of them, forgot to set an alarm clock or something. Like anything could happen. So 18 responsible people, and not one of them fell asleep. Because there's some boring testimony, but not one of them fell asleep. They all were taking notes the entire time. One guy filled in 5 notebooks worth of notes, and I'm looking at this jury, and I picked out my favorites beforehand because in case there were shenanigans, I want it on the record here. I ranked the jurors 1 through 18. My number 1 ranked juror was Paula. Okay, as it turns out, who turned out to be fucking awesome. Who was your favorite juror? Was she your favorite?
I will defer that question.
Okay.
My favorite juror was every single juror who was on that jury. I loved all of them. And I, like you said, all the alternates could have swapped with any of the sitting jurors. And I think the same result would have happened. And that's all I cared about. I thought all of them were great. We were very, very happy with every single juror that we picked during the jury selection process, which was vitally, vitally important. We just got a good feel as a team.
It is the most important part of it. Any trial. That's my opinion. Jury selection is the most important part.
We got a good feel for each one of them. And by the way, I will say, Karen Reed, amazing at distilling the character and quality of people like that. She had a huge hand in picking her own jury.
Who did you try to vet out? What kind of people did you try to vet out?
People who would overthink, PhDs, overthink, PhD analysts, engineers, overthink. Stop overthinking. Stop trying to try the case that I want.
Isn't that interesting? Because it's like the data and all that stuff's good for them. So some people thought maybe they want people like that. But defense attorneys usually have that mindset. Don't take the people that are going to overthink, try to do your job for you, pick apart your defense. Interesting to hear him actually reveal that. It's cool.
Try, listen to the case. What we wanted was people who were open to listening.
They felt like they had the simple explanation and the answer, and just what's easiest and makes most sense, go with that, reasonable doubt, no collision, and be done. Don't try to take it farther than it needs to go.
To the evidence as it was being propounded. Don't try to figure out how would I have tried this differently. That's in my view, that's the death knell of a defense in terms of jurors trying to overthink and outsmart what the defense could or should do. Just listen to the evidence as it's propounded. Be open-minded. Where is the credibility? Who has more credibility than who or whom? And that's what we got. And I'm super happy with them.
Speaking of credibility, I did not know there was x-rays until you guys brought out I thought you guys were like architects, like, Mike Brady, Mr. Brady coming out with your big rolls of stuff there. I'm like, what the hell is this? And it's a goddamn x-ray.
There you go.
What, how long did you know that? Did you know there was x-rays in the first trial?
We knew there were x-rays. We were waiting for the right moment to reveal the x-rays. So
that was crazy.
Yeah, it was great. It was great. And like I said, in certain circumstances, the Commonwealth was our best friend in terms of what they propounded. So that was a real revelation. You never know what evidence is going to shake out in a trial, and you have to be willing to sort of pivot and figure out kind of what they're doing and what you have. One of the things that we weren't going to get caught flat-footed on was our understanding of the actual evidence. We were never going to be outperformed on the details of the evidence that existed in the universe of data.
So like when Judd Welcher said there's no x-rays, you must have just been thinking to yourself like, oh, glad you said that. Yeah. Do you think that Hank didn't call Judd back?
Yeah, it's very interesting to think they knew that and didn't call it out. The strategy, again, anybody that does this for a living, I'll just tell you, it's just like whatever you do for a living. Have you ever had like construction done on your house and then have some other general contractor come look at it? They're always like, ugh, they did it like that. They used those bolts. Oh, it's always like, that's just how it is. Lawyers are no different. When you see somebody try a case, you're like, I would have done this differently or that differently. That's what makes it fun. That's what makes it cool. But like I said, when they win, it all comes up flowers, roses. It all comes up roses, daisies. I don't know. It all comes up good. I don't know the saying. I'm butchering it.
Because Judd would have snitched on him and said, he never showed me. He told me there were no x-rays.
I'm guessing, number one, that's exactly what happened, that Judd Welcher was never shown any x-rays. But number two, if that's why Hank didn't call him back, you'd have to ask Hank that, and Hank ain't talking.
Yeah, he's not taking any questions. He's going to disappear.
I'm going to have to.
Hank ain't talking.
Okay, well, thanks. All right, I really appreciate your time coming on here. I'm sure you're very busy.
It's been a lot of fun. I will tell you, if I can say one last thing in parting, as you probably know.
This is important. Let's listen to this because we're going to just quickly comment on something. I do not want it to get aggregated or become some big deal or big thing, but people have asked questions. I'm going to put them up on the screen and then just talk about why people have kind of been sending me these types of questions.
So I've been very circumspect about doing any interviews after the Karen Reed verdict. It's been very circumspect about doing any interviews after the Karen Reed.
He's been very circumspect about doing any interviews after the Karen Reed verdict.
It's been a whirlwind. I think I want to show her the respect. I think her wishes were such that she didn't want a big press tour of anybody.
Respect her wishes. She did not want a big press tour of anybody.
Any of her defense team going from place to place to place. I wanted to respect that. I have not done it. And I chose to come on your show simply because you have been there, Aiden, from the very beginning. That means something to us. I haven't been able to talk to you very much because we've been in trial 1, and I couldn't really talk to you then. And then in trial 2, I couldn't really talk to you then. But now that I have you and I have a bent ear, I want to tell you what it means to us as a defense team. For me as a trial lawyer, to have somebody like you in our corner. You've been there from the very beginning. As soon as you learned about this case, you unleashed holy hell on that community to make sure that the truth was told. That's not lost on us. That's why I'm here tonight.
Well, that means the world to me, you saying that. And it did it because it was the right thing to do. And it was a pleasure getting to know you and the rest of the defense team and Karen. And just, there was no conspiracy to commit witnesses. We were just bouncing. Like I was just a guy writing a story, talking to, and you guys were giving me only things that you could legally give me. And, stuff that was already in court records. And it was just a phenomenal story. It was an easy story to write because you guys were so good at your job. So thank you for everything you've done as well.
Keep up the good work, my friend.
All right.
So plenty of flowers for Turtleboy from Alan Jackson. So a lot of people have been asking me questions like this, and I didn't know why. I was like, what are they talking about? Then after watching this, I understand. Peter, it seems like AJ and David Yannetti and Bob Alessi do not have a good relationship. Peter, do you think there's some dissent between the defense attorneys? His comments seem pretty different than what Yannetti and Alessi have been doing. So here's what I'll say. Everything that's been publicly facing that we have seen and all of the way that they spoke about each other has been nothing but good, respectful, appreciative. They worked incredibly well together, not for one trial, but for two trials. There was a stark difference, I will agree with you, between Alan Jackson's interviews and Bob Alessi and David Yannetti. But here's what I'll say. Is there any dissent between them? I don't know. I've worked on teams where you're incredibly cohesive and it's all great. I've worked on teams where I've hated working with lawyers from other firms, don't feel like they're pulling their weight, don't feel like they're doing a good job, or they're being a pompous jerk, whatever. I've worked on teams like that as well. I would say my guess is each one of these attorneys is trying to do the best they can to be within Karen Read's wishes. Some may think that means not doing any interviews. Some may think that means you can do one interview and you can talk strategy. Some may think that means you can do as many interviews as you want, but we're not going to talk about the case specifically. We're just going to talk about, what it's like, people involved, generally the practice of law or trying cases. So I think that they are all trying to do what is right by Karen Read, and it may look different lawyer to lawyer. I don't think there's any beef. I don't think there's any bad blood. I don't have any reason to believe that. Again, talking to Yannetti and Alessi, they had nothing but good things to say about Alan Jackson. Talked to some people connected to Alan Jackson. I have not talked to Alan Jackson. Seems like it's all cohesive. Seems like they're still on the same page and respect each other and appreciate all the work everybody did in the case. Okay. So from my perspective, I don't think there's any bad blood, but I did think it was very interesting the amount of questions I got asking that specific thing. And I do understand it based on some of the comments, based on, Yannetti and Alessi being together, doing interviews, and Alan Jackson. I think they're all making their own decisions. They all have their own firms. They're all individual people. They're all adults. They're all lawyers. So I think that's just how it is. And everybody makes their own decision doing what they think is right. That's just my opinion. I don't know. I haven't asked them about that specifically. I haven't had continued conversations with anybody. But that's just the feeling that I got. And that's all we got. It was a little long today. Hopefully you guys liked it. Hit that like button if you did. Make sure you are subscribed. Tomorrow we will be breaking down in some form or fashion Brian Kohberger's sentencing and what happened today. That's it. That's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.